Hello, everyone, and welcome to Stress-Free IEP, the show where we help families build their village to raise their neurodivergent children with confidence and support. I'm your host, Frances Schefter, special education attorney, advocate, and fellow parent, walking this journey with you. Each week, we shine a light on the professionals, resources, and real-world strategies that can empower you to navigate the IEP process and beyond without stress. Whether you're tuning in live on Facebook or YouTube or listening later on your favorite podcast app, we're so glad you're here. Let's dive in and meet today's amazing guest. Cary Jacobson is an attorney, mediator, and founder of Jacobson Family Law, where her mission is simple but powerful: keep the drama out of divorce. Through her work in divorce, mediation, collaborative law, separation agreements, and prenuptial, postnuptial planning, Cary helps individuals navigate family transitions with dignity and clarity. She's also the host of the podcast Divorce Diaries, Lessons from the Trenches, where she shares hard-earned lessons and practical strategies from real-world family law cases. Cary's known for her practical advice, client-first approach, and commitment to out-of-court solutions. And if you're wondering why I'm having Cary on the show with divorces on an IEP show and how that works is, as we all know, divorce is a reality. So is the need for prenups. But there's extra twists when we add our neurodivergent children in. So it's important. And to me, keeping the drama out of the divorce is most important for our children to be okay. So Cary, welcome to the show.
Thank you so much for having me. I appreciate it.
Yeah. And so what does it look like in practice about keeping drama out of divorce? Because, divorce is hard.
Divorce is hard. And even when we're trying to keep the drama out, that doesn't mean that it's that there aren't challenges, right? Because it's absolutely an emotional time and we absolutely recognize that. But what we try to strive for is not to make it more complicated than it needs to be and to reduce that stress as much as possible. And one of the main reasons or ways that we go about doing that is kind of rethinking the approach and not filing for divorce in court right away. So we really work with our clients on trying to help them reach a resolution on all of the issues first outside of court, so that then their matter, once we get to court, is just a simple uncontested divorce.
It's so funny how our tracks are so parallel, because it's the same as we try to do with Stress-Free IEP, is that we try to have IEP meetings, play nice, we're all a team. It's all about the child.
Exactly.
And hope they don't do anything. But if they do, we do what we have to do to litigate, right?
Right.
And so, divorce is scary. Here you married somebody that you thought the love of your life forever, and now you're going through a divorce. So, what are some of the common mistakes you see people making?
Yeah. I mean, I would say the first really is not knowing that there are alternatives and starting that case by filing in court first, because oftentimes what happens is when people do that, it unnecessarily inflames the situation and makes negotiation more challenging. And so really, by focusing on trying to resolve things outside of court first, you have a lot more control on, what those negotiations look like and keeping the temperature down between the parties, right? I would say the other piece is not recognizing that this is going to be such an emotional issue and not having the support team in place. So I always recommend to our clients to either work with a therapist and or a divorce coach through the process, even in uncontested scenarios, because that is really a place where you can ensure that your emotional needs are being taken care of, so that once you get to the point where you are negotiating, it really is a business situation at that point. And so it kind of takes a lot more of the emotions out of it as much as possible.
That makes sense. It's reminding me of when first out of law school, I did family law for a year and a half in Palm Beach County, and I did a divorce that was It was uncontested. It was, I think they'd been separated for like 30 or 40 years. Like it was something ridiculous. They'd been, but it was just like, they never did the divorce. And when we did it, my client cried still,
Yeah.
which, like it
It's
was
surprising, isn't
still,
it? But yep.
yeah, hadn't been together in decades, and he was living with somebody else, but it was still like that emotional letting
Mhm.
go, of terminating it.
And I see that so often. It's, even when, the couple is amicable and they both want this, there's still something about the finality of
Yeah.
that hearing, right? And so it definitely is an emotional situation.
Yeah, definitely. And so I heard you mention, or I know we talked about, or I mentioned that mediation and collaborative divorce.
Yeah.
And so I'm sure a lot of people don't know, like, well, wait, what's collaborative divorce and what's mediation? So can you explain the difference a little?
Yes. So mediation is probably the one that is most common. Most people have at least heard of it. Mediation is where and when I'm referring to this, is divorce mediation, because you can really mediate any kind of dispute. But when I'm talking about this, is talking about divorce mediation. It's when a couple is working with a neutral third party. So I work as a mediator, and when I am a mediator, I am the neutral between the couple. And what that means is I am there to help facilitate the conversation between them. So we go through and address all of the issues that they may need to deal with. If they have children, obviously, we're going to deal with issues related to custody, how they're going to share time with their children, how they're going to make decisions related to their children. Obviously, education is one of those big components when we're talking about decision making and legal custody. So comes into play. We talk about how they're going to handle expenses related to their kids, divide property, anything along those lines. And ultimately, our goal is to help them reach an agreement on all of those issues. In mediation, it is optional for them to have attorneys present or kind of outside, kind of guiding them in the mediation process. The other big distinction between mediation and collaborative is that mediation is meant to be voluntary, and we really want people to participate in good faith and be transparent, and that sort of thing, so that they can come to an agreement. Collaborative divorce is a different out-of-court resolution. They're similar in a lot of ways because they're both out of court. It is both, in both scenarios, it is the parties who are reaching the agreement. It's just in collaborative divorce, it's meant to be more of a team approach. So in collaborative, a true collaborative case, both attorneys are going to be collaboratively trained. The parties may also, especially when we have minor children involved, they're going to have divorce coaches, often one each. And then we may have other professionals that come in, such as a financial neutral. We may have a child specialist that kind of talks with the child or children themselves. And then the intention is everyone on that team is working together to help this couple reach their resolution. The main difference between this and kind of mediation is that team actually signs a document referred to as a participation agreement. And it says that they are going to continue this process. And if for some reason that the process does not work, the parties actually have to hire new team members if they go to litigation. So it kind of gives them a financial buy-in into the actual process.
Although, sorry, I was going to say, talking about that, like I'm hearing like, oh my gosh, you're hiring 2 lawyers and then you're hiring and then you're hiring and then that it can get expensive.
It can get expensive, yes.
But I'm sure it's still cheaper than litigating.
It is still cheaper to litigate. Cheaper than litigation, absolutely. And I only recommend collaborative in very special circumstances. It's typically for those folks who need that extra support team. And that could be for a variety of reasons. I often recommend it if we're talking about a very, very young child, like 3 or under, because the divorce coaches are the ones that help the parents come up with a parenting plan. And I think that those mental health professionals are absolutely equipped in helping figure out the most child developmentally friendly situation, it would also be really helpful if the children have special needs, because those coaches are going to be much more suited and equipped to handle helping the parents figure out what is the best schedule for a child with those special needs, right? The other situation may be if one of or both of the parents have their own mental health concerns that limits maybe their ability to understand or to kind of work through the process separately from a team. Sometimes substance abuse can be another reason. So we still are trying our best to keep these folks out of court so that they can still find a resolution that works for their family, but they need more support than just a traditional mediation situation.
Right, I understand. And I'm just thinking about some stories I've had. Like, I've consulted with people going through divorces before they've hired me because they were concerned. And I know, it's hard. Things you don't even think about when you have the younger children is like, well, what about middle school? What about high school? What about college? What about if this is a child that's going to not be able to live on their own?
Right.
Who's going to do guardianship? Who's going to do that? And there's like all those other things that, that you don't even think about because you're just thinking about the now, that there's so many others. And then I'm just thinking about it with the collaborative divorce. I'm assuming the signing is similar to like mediation so that everything that happens is confidential.
Absolutely.
Right? Yep. So none of this can be used when you go to litigate. You can't say, well, in mediation, you said.
Absolutely. Yes. Everything that is in those sessions is completely private. And so ultimately, if parties are able to reach that agreement, then nobody knows the why or the what happened, right? Because the only thing that gets shared with the court or anyone in the public is really that actual, the final terms that the parties have come to.
Right. That's awesome. And so is it kind of like I'm envisioning this whole room with everybody. Is it like that? Or is it more like we meet with the accountant, that we meet with the coaches, or?
Yeah. So it honestly varies. So in the collaborative space, the parties will work with professionals separately. So they would, and when they're working on their parenting plan, they would be the parents as well as the coaches working together through the parenting plan. Then when they're addressing issues related to creating their budgets or their asset list or their liability list, they're going to work with the financials person individually. But then when they're coming, like basically trying to finalize full agreements on the division of property or financial support, many times we are meeting all together. Since COVID, we are more so doing it in the virtual environment, which makes it so much more accessible for everyone because now people are not paying their professionals to travel, that sort of thing. Sometimes being in person can be helpful, but it just broadens, access to professionals because now we can really work all throughout Maryland. And, we can break out into different breakout rooms as necessary to talk to our client individually before they, if they have questions or whatever the case may be. But ultimately, the goal being that they come to that agreement.
Yeah, that's good. I will say one of the things that I see often that frustrates me, that probably divorce attorneys don't even think about, is in any type of agreement, they don't have tie-breaking authority.
Yeah.
And so I'll get a case where I'm representing mom and, mom and dad have equal. And mom wants a non-public and dad says the kid's not special education. And so schools aren't going to get involved. Schools are just going to kind of like, we're doing nothing. You know what I mean? And so the kid suffers in that point because now what? Now you have to go back to court and who's right and hire your experts and all of that other stuff. Whereas if you're in the collaborative space or the mediation space, you can say this person or that person has the deciding factors. Because it makes sense. And then you could, do something like, well, you have deciding factors for this, but I have deciding factors for that, so that it evens it all out.
Yeah.
'Cause
And then
that could
sometimes what people will do is they will do joint legal and then say, if for some reason they come to an impasse on a decision, so if education happened to be the decision that they could not reach an agreement on, that they would actually come back to mediation to address that issue first before going back to court. So it gives them an opportunity to have that conversation in mediation as to, okay, well, why and what do we need to address, right? And what solutions can we reach to address that particular situation?
Yeah, that makes sense. So mediation, so you've explained a little bit about the difference, but prenups, I know that's a big thing, especially to go that way, Taylor Swift getting engaged and stuff, everybody's like, she's got to have a prenup,
Absolutely.
And right. I mean, thinking about it, like I would almost recommend it for everybody, a prenup or a pronup, right? Postnup, get the words out right. A prenup or a postnup. What's the difference and why are they so important?
Yes. The difference truly is just a matter of timing. A prenup being signed before you actually get married and a postnup actually being signed after, anytime after the marriage. So sometimes it's just they wanted to do a prenup, life got in the way, the wedding planning took over, and they just didn't get to sign the document first. And so they're signing it as a postnup. Sometimes it is parties have been married for several years and either something new has changed. I often see it with one of the spouses, like starting a business is a pretty common scenario. It could be that someone has come into an inheritance that they want to make sure that they've completely protected. Or maybe the marriage has hit a rocky spot and they also want to just settle the financial issues now so that they don't have to worry about it. And if something happens down the road, those issues have been dealt with, right? So that's generally the difference between a prenup and a postnup. As far as who should have one, generally I recommend, the idea is you have one, whether you know it or not. It's either one you create or the one that the law in the state that you're living in creates for you. So it's really just a matter of what do you want to have control over as far as how your assets are going to be divided if you happen to get divorced in the future. And the other thing most people don't recognize that it can also address if one of you dies during a marriage. And so that becomes even more important for those second or subsequent marriages.
But would it work with a will instead of well, obviously not instead of a will, right? Like
kind of in conjunction with.
Got it.
So basically what happens is in Maryland, if you do not have a prenup, you cannot disinherit your spouse, right? So what happens is if I am getting married for a second time, maybe I have adult children, right, from my previous relationship, and I want my assets to go to my kids when I pass away, right? I can't do that without having a pre or postnup because my spouse is entitled to a specific portion of my estate when I die. And it varies depending on exactly how, if you have kids, if how, that sort of thing. But I can't do that if I die and I want everything to go to
even if it's in your will that everything goes in your will,
because my spouse could then come back and say, I want my spousal share.
Which is what happened with to date myself, Pamela Anderson, right? Way back when. But I didn't even think about that. That's a huge thing, especially for anybody doing second marriage. And I would say like now, even, with children and especially with neurodiverse children, because what happens if, and then your kid doesn't have the money that you thought your child had because of whatever happens.
Right. So it's very important for those people who have second marriages. But I think even more so these days with the first marriage, it is an insurance policy. Right. That's the way that I kind of view these documents. It is meant for you to have a frank conversation with your future spouse about finances and how you're going to handle them. And so many people these days are waiting and getting married later. So many people are coming into marriages with a house and retirement and bank accounts and investment accounts. And so addressing those things in a prenup as far as what's going to happen to them in the future is critically important.
Yeah, that makes sense, because it just, yeah. And then doing it when you're in a safe space. I'm thinking, of course, where my brain goes is like, I can imagine people starting to do a prenup that are supposed to get married and digging into all this stuff and then realizing they're not as compatible as they thought they were.
Right.
Right. And prevent the marriage, which I hate to, like, but it's something that be like, if you don't realize financial positions, not that finances, but, financial or this or that, or the things you go into, which are the big picture. You're just doing the feelings and the love, which is great. Yes, we all want feelings and love in marriage, but we want to be compatible in future and future planning.
Mm-hmm.
And if you have somebody that like, oh yeah, I have $500,000 in debt and whatever, and another one that has 200,000 in savings already, like that's a big difference in how people think that money should go and where it should be spent, I guess. And, and that type of stuff.
I think financial compatibility is a huge piece of a relationship because it truly can make or break a relationship. And I don't think as many people have the conversations as they need to prior, and so they're just trying to weed through it as they go. And it's one of the main reasons people, separate and divorce later, is because of they don't see eye to eye on how they're going to handle finances.
Right. That I was going to say that I had heard that somewhere at some point also. Yeah, because, and thinking about it, like finances impacts everything, like stress levels. And then when your stress levels are high, how you parent might change, how you interact with each other, everything else. And so if you don't know where you are financially, that can be a challenge.
Yeah.
So what about, the LGBTQ plus community? Because, and I have not kept up on it as much as I should, but as far as I still know, some states accept it, some states don't. How are prenups and postnups, impacting that community especially?
Well, I would say that as of now, the current federal law accepts same-sex marriage. It is questionable whether or not that is going to continue. I believe there is a case working its way through for that to potentially be overturned by the Supreme Court. It's up in the air, which is one of those reasons why it is so critical for people of the LGBTQIA community to really have everything that they need in place. And obviously, if something happens, then it's going to be dependent on the state that they live in. But obviously, prenuptial agreements are a great option. But the other important thing, especially for your listeners who probably may potentially have children together, is also making sure they have their second parent adoptions in place. Because that's going to be the bigger concern, I believe, in scenarios where it ends up being state specific. Because if you don't have that in place, then that could become an issue again. So making sure that you have the second parent adoption in place in those states where it may be more critical.
Yeah. And I'm thinking about it and in cases because when, I guess legally, if you call a hospital, if you're not a parent on the birth certificate or have something that you're the parent, you don't get any information. And if God forbid it's, your partner and the child, then what? What happens? The state comes in. Even think about like that side of it, of how important it is to make sure that, and do you help with second parent adoption, or is that?
Yes. So I believe in Maryland, we are likely to be relatively safe from a lot of that because Maryland has a lot of those things already kind of in place. And I hopefully do not foresee a lot of that getting overturned. But just to make sure that people are protected. It is making sure that they do have that second parent adoption. And then the estate plans, as you mentioned, powers of attorney so that they can, work on behalf of the other, make those decisions, especially if they're not considered married any longer. All of those things kind of come back into play.
Yeah. I say that all the time about in special education also with where, clients ask me, I'm like, you know what, in Montgomery County, Maryland, even in Maryland in general, I'm not as worried,
Right.
but hey, you're talking about marriage. You don't know where the future is going to bring. What
Right.
happens if, one spouse gets the dream job out in Utah,
Right.
and you all move to Utah because that's what you want to do. And then, laws change, something changes. If you don't have that stuff in place, and at that point, like, I don't know. And I don't know if you know or not. So sorry if I'm putting you on the spot, but like, are second parent adoptions allowed in the LGBTQ community? I mean, like now, like, what is the rule on this second parent adoption? Can it be same sex?
In Maryland, for sure. Yeah.
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 But in some states it might not.
Right.
And then that's the problem. And then even if they do, then there's the whole, and I don't want to go into all the legal stuff, as we know, there's the whole other thing of like, do other states have to recognize it?
Right.
Which is why the feds stepped in with the marriage, because it was just like, well, I got married in New York, and wherever is saying, oh, too bad, we don't recognize it. You're not married.
Yeah.
And there's problems, which is so. Ugh. I'm trying to think of what else would, like, what I didn't ask that is something that you think people should know, or if we covered it all.
Yeah. When it comes to children with special needs, in mediation, making sure that the parents are kind of thinking that the future focused, as you mentioned before, what if your child is not going to be able to be financially supportive or financially independent, right? So we've definitely handled situations where we've addressed which parent is going to kind of receive money on behalf of the child or children, how they're going to. Also, we want to keep in mind how that may impact any benefits that they may receive from the state, right? So we have to take those things into consideration. But really, I'm a huge proponent of mediation or settlement negotiation so that we can address those specific nuanced situations that are just so particular to that individual family.
Right. And I'm just thinking about like all the little details that people don't even think about and don't even know when they're doing things. Okay, so what happens in the future if, God forbid there's an accident or something and the child becomes, like, what are we doing there? Like, is that, I would assume it's like your will that, or living will, that you kind of go through all the phases of like, if this happens, then we do this, in that sense, in a mediation, a prenup, postnup, to an extent, because you can't do everything.
Right. So obviously, fortunately, most of the people that I am working with in the mediation setting truly are parents who have their kids' best interest at heart, and who are working together for the benefit of their children. If there happened to be a scenario in the future where they needed to come back, that's the other great thing about mediation. I've had 2 people within the last week who I've worked with previously on their divorce matters now want to come back and make adjustments because something has changed. So we can always do an amendment to the previous agreement to address new things that have come up, or to make revisions to something that they previously had in their agreement. So that's another beautiful thing about mediation, is it's not necessarily just a one and done situation. It is, let's revisit these things and address them as they come along.
Right. Which makes sense because, 10 years down the road, there's an inheritance or something, you never know, or opening a business or, something of that sort. And that just gave me a thought though, for collaborative divorce,
Mhm.
Do you, in that agreement, do you put in that you will mediate before litigating as well?
Oftentimes, yes.
Yeah,
Yeah.
that's what I would think. Because like you're in that collaborative joint space.
Yeah.
And so it's easier. I keep thinking about the brain and how when you're stressed out, which you're going to be
Mhm.
regardless, when you're stressed out, your brain's not functioning 100%,
Right.
and then it's like center yourself, and then you can think more clearly. And that's what I'm thinking with mediation and collaborative divorce. That's what they are. Because if you need that minute of like, you know what, I need to step out for a minute,
Right.
and then get yourself in the clear headspace and then come back.
100%. And we can
Yeah.
always take those breaks, whether it's during session or in between sessions, so that, people have an opportunity to take that minute to assess what they've discussed and, the proposals that have been made. Maybe it's consult with another professional. So they could have, in the mediation space, they may not have attorneys in the room or in the virtual room, but they may have an attorney that they're working with. So they could do a meeting with that person in between session. Maybe it's they need to talk to a real estate agent or a mortgage broker or a financial professional, so they can have all of those outside resources kind of on point in between sessions to address issues before like actually signing the document.
That makes sense. So I'm thinking, like, I know you're in Maryland, and I'm thinking, like, with mediation, is it same as us as lawyers that you have to be licensed in every state you practice in, or
No,
no?
no.
Interesting.
As a mediator, I am not quote unquote practicing law. And so as a mediator, I really can work with couples no matter where they are. It's just that we would not be able to, file the paperwork or help the parties kind of finalize the divorce. They would do that with an attorney or on their own in the state that they're living in.
Got it. That's so funny because it's the same thing with me as being an advocate. I can
Right.
be an advocate any place that I'm not licensed because you don't have to be an attorney to do that. But if you
Right.
want to litigate, there's the
Yep.
other. Um, it's it's so funny because every time I do my show, I learn something new, and I'm like, wow, and I've been friends with you for years, so like I've known you forever, and I'm like, oh, I didn't even know she did that. Like, that's why I love my show. But this has been so awesome. Thank you, Cary, for coming on the show. How should people reach you? Like, what's the best way of like, oh, I want to find out more about this? What's the best way for them to reach out to you?
Absolutely. Our website is absolutely the best place, which is jacobsonfamilylaw.com. From there, you can find us on socials. You can schedule a consultation online. You can learn more information. You have access to our podcast and our blog. So everything can be found there.
That is awesome. Thank you so much. And thank you for being on the show.
And thank you for having me.
And thank you all for joining us on this episode of Stress-Free IEP. We hope today's conversation gave you new tools, insights, or just a little more peace of mind as you support your neurodivergent child. Don't forget to subscribe so you never miss an episode. And if you found this episode helpful, please share it with someone in your village. You can always learn more and connect with me at schefterlaw.com or follow along on social media. Until next time, remember, you do not have to do it all alone.